Last case on this afternoon, matter of Corrigan v. New York State Office of Children and Family Services. Counsel.
Good afternoon. My name is Peter Hoffman. I'm here on behalf of the Corrigan family, and it may please the court that we believe that this...
Sorry to interrupt you. Do you want rebuttal time?
Oh, I'm sorry. I want 3 minutes of rebuttal.
3 minutes.
Excuse me.
Thank you, counsel.
In analyzing the two statutes that are in question here, Social Services Law 422 and 427A, we believe that they should be read together, as we stated in our papers. We believe that they should be read together because, contrary to what, they should be read together in a theory of pari materia because...
But they're not the same, are they? One involves a full investigation of whether the charges are, the allegations are substantiated. One says, we're not going to go there. We're just going to try to address whatever issues have been raised. We're not going to make a finding. So from a practical standpoint, how would you, what would even be the criteria for expungement?
Okay. So, Your Honor, firstly, the statute is part of the same group of statutes. It's part of the Social Services Law. It's not as...
Law. That's a pretty big law.
Understood, but it's still part of the same construct, as it's stated in...
Right, and one says that the records must be maintained for 10 years, right. And the other says, unless
Okay.
that you can seek to have it expunged earlier.
But let me go to answering the other part of your first question. I want to go to, and then I'll get to this third question. But in the context of why they're the same, and why they're similar, is because when you look at the legislative intent, in particular, Senator Rath, one of the introducers, says clearly that one of the reasons that 427A was meant to put in place was that a record could haunt one for years later. And that's on page 12 of the bill jacket.
That's right, and here, in this situation, there is no record that anybody has found anything.
Right.
So, and that's the record that could haunt, but the legislative intent also indicates that when there is no investigation, that maintaining these records is important because it may be the only chain of evidence if there's problems down the road.
And I agree, my client agrees, and we don't disagree with the 10-year retention portion of this. But the 10-year retention portion, if you look back at 422A, the 10-year retention portion is even more important in 422A. But yet, in 422, what it says is that even though we have somebody that's founded, they can go back and have a specialized hearing, then go back, and if they're successful in that specialized hearing, go back and get expungement.
And what is that hearing based on?
Excuse me?
What is that hearing based on? Isn't it based on the investigation?
No, it's based on clear and convincing evidence as to whether or not the falsity or the truth of the charges.
Right, but part of that evidence is what was gathered in the investigation.
Nothing needs to be different. Nothing needs to be different in 427A than is applied in 422.
So in this case, counsel, where everybody agrees there was some kind of misunderstanding about what happened with this young man, with the boy, and the family, didn't do anything wrong. And so they just want, even though there's been no finding that they've done nothing wrong or that they did something wrong, they just want the record expunged.
Well, there's 168 pages of records that are left over from this investigation. It's not insubstantial. This is part of my practice as handling a lot of administrative law, but this in particular, CPS charges are part of my practice. 168 pages of records left for someone to go look at is very dangerous to that person.
Let's say, I think personally, it's unfair. I think that as an individual, I would agree with you. But I can't say that I don't see a policy reason why the state wouldn't want to do this in terms of forgetting about you and your, a general policy reason why the state really wouldn't want to protect its ability to identify a pattern of abuse. So,
We don't disagree with that policy.
should the law be amended? That's a good argument.
Well-
Do we have the right to modify 427A to put it in line with 422 in the absence of any kind of investigation, any kind of finding, either unfounded or founded, identified? That seems to be an entirely different question. The fairness argument, you win. But it's very hard for me to see how the state's interests can be ignored here.
Nothing affects the state's interest in retaining records any different in 422 from 427 if you allow 422's procedure to go forward.
No, it would.
And the reason...
Let me explain a second. Hold on. It would, because it's simple enough. If there was an accusation of abuse, it went on an FAR method or investigation, it was dismissed, nobody did anything with it, and then 5 years later, there was another claim of abuse that was founded, there would be no record, it could be expunged under your theory. Here, it cannot be expunged. The more pressing problem is, why can't it be expunged after 10 years? The way I read the statute is it can't even be expunged then. I agree with you, there's some unfairness in the way the statute operates, but that still doesn't undermine the state's overriding policy to protect against a pattern of abuse.
I agree. In the context of the 10-year retention rule, there is no disagreement. But where I disagree, Your Honor, is that if we were to use the standards for expungement under 422, which is clear and convincing evidence, it's a fairly high standard,
Yeah, but
by which...
let's get back to Judge Stein's question, because I think at the end that's really the nub of it. When that determination is being made, is that going to be a de novo review? Is there some new investigatory process that's going through? Or are you deciding that, or will that be decided on the record as it exists? Which then there are two different, right, there isn't a full investigation under FAR.
Understood, but you would still have to reach the issue of clear and convincing evidence as to the truth of the matter of whether or not abuse occurred or neglect
But the question
occurred.
is based on what? I think that's what.
Based on in this case, based on 168 pages of records that clearly show that the district was not reporting factual information to CPS, that sits there.
If that's the case, Counselor, then what's the harm? You know, you say we have these records that anybody can look at. And
So-
of course, the statute very, very narrowly defines who can look at it. But even as to those agencies or persons, if the record, as you indicate, shows so clearly that they weren't at fault, then what is the
Because someone in a position, in a bureaucratic position, in a busy office, in a metropolitan area such as Westchester County, which is theoretically urban at this point, and the type of caseload that person has, is not necessarily going to look at each and every 168 pages. They're going to look and say, this person was not investigated, this person went for an assessment before, why should we put them on an assessment
The
again?
petitioners have said, we don't want to go this route. We want an
I-
investigation because we can prove that there's no foundation to this.
Your Honor,
Can you address the notice issue?
Your Honor, I do that routinely now with my clients after this matter and becoming aware of this matter. After this matter, I know of other clients who have gone before CPS, been posed the question, do you want a FAR assessment, or do you have the option to go through a complete investigation?
But
It is never told to them
Okay,
that they can get an
preserved here?
expungement.
They make the argument,
Excuse me?
they make the argument on this notice, or lack of explanation, is that preserved for us to consider?
It is preserved. And I believe there was a lack of notice, and a part of the
Well,
lack...
you've got the checklist, what shows the
But the
lack of notice?
checklist doesn't say, the checklist itself, number one, doesn't say that the parent or the person who's charged is given the right to choose one or the other with the information that expulsion would be okay in an investigation.
saying
The parents sign the checklist?
Parent, I can't remember, but I don't think the parent signs the checklist. I believe that the caseworker signs the checklist.
Does the parent sign anything to indicate that they consent?
Not that I'm aware of, Your Honor, no.
So that would all be based on
On the word of the
representations
caseworker.
from the caseworker?
Right. And in this case, even if, as I read the regulations, even if notice was given, which I'm not disputing that some form of notice was given based on the checklist being signed. But by the same token, under the regulation, nothing in the regulation says to that parent or that person who's charged that you will then necessarily be giving up the right to expunction.
Was there any investigation of that assertion,
Not,
to your knowledge?
not to my knowledge.
Thank you,
Okay,
counsel.
thank you very
You have
much.
rebuttal.
May it please the Court, Valerie Figueredo for the State Office of Children and Family Services. There is no early expungement here for two reasons. First, the plain text of the statute requires that a report under Social Services Law 427A be maintained for 10 years. And second, the early expungement provision in Social Services Law 422.
What's the process if someone says, that was not explained to me, I didn't understand that expungement would not be an option? Is there a process now to address that?
The family, before the FAR case is closed, the regulations require the local social services district to inform the family that the report will be maintained for 10 years. At that point, if the family wanted to perhaps submit to an investigation for the possibility of an opportunity for early expungement,
No,
they
no,
could
I
then
understand, I'm
switch.
sorry. If the family comes back and says, we did not know that, we would never have consented to this, does anyone investigate that?
OCFS does not conduct, that's up to the local social services district. That would be a lawsuit against Westchester DSS. The family could attempt to seek some type of civil action against the district claiming that they were negligently put on the FAR track, but it would not be a lawsuit involving OCFS because OCFS in the first instance is not the entity that either investigates or notifies or talks with the family. They have no contact with the family.
So their remedy here, if they want to pursue, in your opinion, they want to pursue this notice question, as you're saying, is to go against
Westchester
the Westchester
DSS.
County. Okay.
So you said they're expunged after 10 years on the fire track, but they really aren't. There's no provision to expunge at all, is there?
There are two separate provisions in 427A. I would refer the court to 427A subsection 4C(i), and that one says sealed reports shall be maintained for 10 years, and after that, they are expunged. And then there's social
Well,
services law.
That's what you're saying practically happens. After the 10 years, they get expunged?
Right.
Not that the statute says that they will be expunged.
The statute only says they're maintained for 10 years, so
It doesn't say they're expunged.
it doesn't actually say they're expunged,
Right,
but
that's
the
my
logical
point. So-
inference.
My point is we're dealing with what the statute says. It does not say that it's expunged, unlike 422, which actually does say that the records are expunged after 10 years.
But 422 does also have the same provision that says they're maintained for 10 years, and then has a separate provision that permits early expungement. That's what's missing in 427A. 427A also has subsection 5C, which says the records are maintained for 10 years. So in two separate places, the legislature made it clear that they shall only be maintained for 10 years.
Only be maintained, you mean
Right.
that they could continue, they could not after year 10 keep those records?
The
Or
OCF,
that they wouldn't have any effect after 10 years?
after 10 years, OCFS understands that the statute does not require, does not authorize them to be maintained.
How can a parent confirm, things happen, that it gets expunged? Do they have to start an action? What do they have to do?
So for early expungement, if you choose to have an investigation and you have a finding that the report is unfounded, then you could submit a request. It must be in writing. You would you would set forth clear and convincing evidence that affirmatively refutes.
But if it's not on the early expungement, if it's just the 10 years, I've waited for the clock to tick, I'm at the 10th year has come and gone.
I
How
think-
if I'm the parent, how would I confirm?
I would imagine they would contact the same person at OCFS who's in charge of the,
So it goes
reviewing
not
the
to
early
not the
expungement.
district OCFS, because it's on the register.
Right. OCFS is the one who administers the register.
And when there is a request for early expungement, what does OCFS actually look at? What does it do to make that determination as to whether there's clear and convincing evidence?
So there's two things the OCFS would look at. First, it's the clear and convincing evidence, the written evidence the family would set forth, showing why the allegation in the report is affirmatively refuted. And two, it is the records of the investigation and the findings of the local social services district. And that's why permitting expungement under FAR would completely undermine the FAR procedure, because there is no investigation, no finding, no determination.
But wouldn't that just
a
mean there's no
one-sided-
clear and convincing evidence? I mean, wouldn't you just come to that conclusion?
It would mean that the
Why can't she have an opportunity to make her case? And if you think the investigation in this particular case was enough, you can render a decision. But if not, didn't satisfy the burden.
Well, one, it would undermine the clear, plain text of the statute, which does not provide for that remedy. Two, it would only provide OCFS with a one-sided perspective, whatever the family sets forth. But OCFS would not have anything from the district, no findings, no investigation, to then assess the family's claims. So it would almost be pointless, because they wouldn't have the full record
Well, that's what I'm
you get.
saying. Aren't you then left with she's not met her burden because you don't have enough in the record to come to a decision?
But again, that would undermine the administrative convenience that the legislature set forth when it created 427A. In exchange for not having the burden and the time-consuming aspects of an investigation, you don't get expungement, but you also don't get a determination of wrongdoing or any assessment or finding against you.
Can we just go to, it seems like the petitioner's arguments really go to a question of fairness and their constitutional arguments. And what's your position on the equal protection arguments and the due process argument? It seems like the petition does not contain any constitutional argument, but the trial court actually seemed to rule nonetheless on an equal protection argument. At the appellate division, there was a due process argument, and now we have an equal protection argument again. So you argue it's unpreserved, but how do you get around the fact that the trial court ruled on the equal protection argument?
So the Supreme Court, and this is at page 19 of the appellate record, interpreted the allegations in the petition regarding the denial of administrative review as an equal protection claim. If you want to reach the merits of that claim, it fails because there is no protected class here. The state does have a legitimate interest, as this court recognized in Lee TT, to protect the child welfare, and that interest is furthered by having this registry. It was a reasonable legislative judgment to protect the family's interest, their privacy interest, by sealing these records. They're not publicly available, and in exchange, you have this registry and you encourage zealous reporting because you are trying to further a legitimate interest in ensuring that children are protected. As to the due process claim, again, our argument is that it's unpreserved. It was not raised in the Article 78 petition, but even if you want to address the merits, there is no due process violation here because there is no legally protectable interest that was affected. There's no allegation as to a loss of employment or the foreclosure of future employment, and you don't have a due process claim.
Do they
just
have to
based-
report this anywhere? Does the parent have to report this anywhere, that they're on the list?
There's
this
no-
registry?
There's no requirement in the statute that it has to be reported. Again, the report can only be unsealed in a very limited circumstance, and just to make that clear, that's only when a subsequent report comes in to the SCR.
If she went to get a job as a teacher, would she have to report this?
I don't know the answer to that. I don't know what the requirements are for obtaining an educator position. I do know that unlike reports under 422, where the school district or a child welfare agency, child care agency would then be able to call the registry and find out if you are on the registry, that would not be available here. So an employer, a child care agency, foster care agency, would not be able to call the registry and confirm whether this family has had a report issued against them or has had a report assigned to FAR.
Counsel, just to go back a second to, I think, Judge Fahey's question earlier about the differences between the 10-year expungement between the two statutes. It seems to me, and maybe I'm reading this wrong, but in 422, which shall be expunged language, it's 10 years from the 18th birthday of the youngest subject, right, of the investigation. But under 427A, it's 10 years after the report initiating the case. Is that right? It's different periods of time, right?
Right, and there's also a different period of time for an indicated report, 28 years.
Right. So under 422, you've got a 10-year shall be, but it's going to start running later. And under 427A, it seems you've got a 10-year from the initiation of the report, but it doesn't have a mandatory expungement.
Except that it still uses the same shall language, the statute.
Yeah, but the 422, I think to Judge Fahey's point, 422.6 says shall be expunged 10 years after.
Right, it is different language, but it is the practice that under 427A, the reports are maintained for 10 years. And they would only be reopened in the event you have a subsequent report, and only then by the local social services district investigating that subsequent report.
And going back to the original point, I think that's 10 years from the investigation, then their understanding is they expunge them, not 10 years from the 18th birthday of the subject.
Right, 10 years from the date of the report.
Right.
Counsel, could you just, I'm just curious about the expungement process. I know it's not available in 427-A, the early expungement. So under 422, if a parent is successful in getting expungement, early expungement, what happens to the records? I mean, are they destroyed? Every aspect of the record is destroyed? What happens?
So OCFS does not actually maintain possession of these records, so the 168 records claimed to be in existence in this case are not in OCFS's possession. OCFS only maintains the computer records that the local social services district inputs into the system. So what OCFS has is just, I think, amounts to about 36 or 37 pages of computer printouts in this case, and that's what I believe would be expunged. And then it would be the local social services district's records of the investigation that would also be expunged, but they're not actually in the possession of OCFS.
What does that mean, expunged? Does it mean they get wiped out of the computer? They get, I mean, if they're physical records, I guess there are no physical records anymore. Would they be shredded? What
So there may be
exactly?
physical records in the possession of the local social services districts. I'm not entirely sure what they would do with those. And in terms of the records at the SCR, they're already legally sealed, so I don't, I guess the answer is I don't know if they would just delete them from the computer system. But they would not even be available in the future. So in the instance that you get a subsequent report after that expungement, you wouldn't have anything to access. The SCR wouldn't provide any information to the local
Well,
social
what
services.
about, I understand there's no legal right to look at the records, but in this age of hacking and all the rest of that, what if you had some neighbor or some other person who was, just bent on sort of defaming you, essentially, and looking into your life and hacking into systems to find out things about you? And might those things get published if they're still in the system? If they were hacked?
So that might be a potential risk, but the legislature had a reasonable basis for, despite that risk, maintaining these records, and that's because they do, over a period of time, they could demonstrate an ongoing pattern of abuse, and there is legitimate state interest here, which is to protect the child welfare, and in order to do that, you need the holistic family history, and those records are part of that history.
Counsel, let me just ask you, 422.5C that provides for that expungement does say may in its discretion grant. So why or under what circumstances might the discretion not be exercised despite meeting the requirements under 5C? Where would may not end up granting this expungement? What would be the reasons for that?
So my understanding of the way the agency reads that language is it's discretionary whether it can provide the review for early expungement, but if you actually provide clear and convincing evidence that affirmatively refutes the allegation, you're granted expungement. In practice, they review all expungement requests. So last year, they got about 237 requests for expungement. They went through the early expungement process and reviewed all of those requests.
So you're saying as a practice, they have read may as shall, even though it says it's discretionary, and they need not?
They need not engage in the review is the discretionary aspect. Once they engage in the review, if the family sets forth clear and convincing evidence that affirmatively refutes the allegation, you are entitled to early expungement. If the family had that evidence and did not get it, they could presumably bring in Article 78 and challenge that as arbitrary and capricious
Yeah, I
by
guess
the
I'm
agency.
not really clear how they're reading it that way, because it says the office, OCFS, may in its discretion grant a request to expunge. It doesn't say may grant a request to consider expungement. But you're saying this is their practice, this is what they
Right,
do.
in practice, all requests go through the process, and if the family were to meet the burden of showing that...
It's granted, they
it's-
treat it as
then it would
mandatory
be
use.
granted. And of course, if the family thought they were wrong, they could bring in Article 78 in that instance.
Okay, thank you, Counsel.
If there are no further questions, we just ask that the court affirm the appellate division's order.
Thank you.
I'm not certain who asked the question, but when as a concerned expungement, this parent did ask for expungement, and there's a letter in the record where she does affirmatively ask for expungement. She also gets a letter back that says that she can have expungement exactly on the point that you're making, that they may or they may not. But the more important point is, I think it was Judge Fahey who said that what will they do if the parent asks for expungement, if I'm not mistaken? So in this case, what they told them was, they didn't say anything about going through, well, if you want expungement, go through the formal process, go through 422 and have an investigation. Instead, what was said was, you have no right to expungement, and we're not going to consider it because there was no founded indication in this case, not unfounded. So I think that's very important, especially in
I
reference to
get
that
it backwards
question.
sometimes, but I thought it was unfounded and indicated is the statutory language, what they use in. I
Right.
thought that was it.
Yes.
Yeah, okay.
But
But I
either,
misstated before, I think.
but either way, when they did ask, when the parent did ask about expungement, the department didn't come back to them and say, gee whiz, if you want expungement, you have to go through the entire process
Well,
of
but
investigation.
Is that an appropriate result? What if it's, what if it's 5 years later? Then going through the investigation that would have been very different around the time that the allegations were made, is no longer possible.
If I'm not mistaken, and I could be mistaken, but if I'm not mistaken, under 422, the time limit for seeking expungement is either 90 or 120 days, if I'm not mistaken.
But even so, again, in the case of 422, there already has been a full and complete investigation that's simultaneous or pretty close to the allegations, which is
Your
different.
Honor, I understand that, but really, what you have to look at is what goes on under 427A vis-à-vis 422, the investigation versus the assessment. The assessment itself is an investigation. The assessment itself, and if you look at the record that was created from the assessment, 168 pages of records were created out of that quote-unquote assessment. So to me, the assessment is an investigation by itself, and it does make findings. It makes findings that, number one, it's not a serious allegation of abuse. Number two, it also finds whether or not the parent is going to cooperate or not. All of these things are very similar to 422.
Why can't you rely on the remedy that she's suggested, on the notice issue? On the notice issue, on the consent issue, I'm sorry. Why can't you seek relief from the local district? And if they agree that she really wasn't informed, didn't really have consent, maybe there's some relief that way.
I don't know that we couldn't have done that, but the point is that they took a very absolutist position, which led us to believe that they weren't going to change their mind on two separate occasions. And that we had a parent that was at risk of, in our opinion, at serious risk of having a record kept and created that could be used against you. You were raising the issue of the random hacker, which we all unfortunately live with now. In that context, I just don't know that that's going to happen or it will happen. But again, it goes back to the fact that the parent is genuinely at risk, even under an assessment tract, because the assessment tract is an investigation. And the findings of the assessment tract to allow this parent to participate in FAR is tantamount to the investigation that would be considered under 422. And I really think that that's the crux of where the parent here is at risk for no reason, and at risk in a way that is completely, this is a person that, just as a scenario, here we have a person who has been wrongly accused of educational neglect. She's put into the FAR tract because there are much more serious cases such as child molestation, physical abuse, whatever, that are investigated and are
He's wrongly
mandatorily.
accused 5 times. Does that suggest something? Isn't that the point, to see if perhaps a pattern develops over time?
Only, but, Your Honor, with what goes on with divorce law, and from my experience, education cases, and that's why we cite the, that's why we cite the HB case and why we cite the AC case. The trouble with that is that, so 5 times there's false reports.
But that's exactly the
And it-
reason why, and it gets back, I think, to the notice and consent issue, is because in that situation, the parent says, no, I want to air this whole thing because my ex is just going to keep coming back.
But even, they could say, I want an investigation, but if what's the basis for them understanding that they should ask for an investigation if they're not being provided notice either the first
I
time
said
or
it's connected to
either
the
the first
notice.
time or the 5th time?
Thank you, Counsel.
Thank you, Your Honors. Appreciate it.